Today we're speaking to Andrew Canter, Chief Investment Officer of Future Growth Asset Management, about the new Credit Ratings Act. Andrew, please elaborate how regulation in the financial industry could aid the healing process post the financial crisis.
Trust was broken in 2008. It was a long time coming, and stresses had built up and behaviors had altered. But whatever led to it, trust was broken throughout society, from all the way up to government, which ended up bailing out investors, banks, organizations, to the consumer who was betrayed by the entire financial sector and felt it, hence the 99%. And there's an outcry for regulation, for some sort of that shouldn't happen again response. So regulation is probably ultimately never the right answer, even though it's a necessity. Law is a necessity. The basic foundations of fair play do need to be regulated. There has to be recourse and punishment. So in that regard, regulation is part of the healing process. It's trying to rebuild faith and confidence in the financial system. As much as sins were committed, the reality is the financial system is part of the foundations of any economy, and if it functions better, we're all better off, which is why governments bailed out the financial system. You couldn't have it stop working. And regulation just plays an important part in that rebuilding of trust, in that re-establishment of efficient markets and fair markets.
Could you explain how the reliance on official credit ratings has been removed from Regulation 28 and CISCA, and what the implications of this are for investors?
At the heart of the credit bubble was the reliance on ratings, and not just that investors used them, and not just that they were in the end clearly not as good as they should have been, or as reliable as they should have been, or as independent as they should have been. It's just they also had a regulatory oligopoly. They were written into regulations that investors could only buy rated instruments. Mandates were written by clients hiring asset managers that you could only buy officially rated instruments, and it created this comfort zone, a safety zone for ratings agents, that they would have a certain business if capital markets would function, where borrowers and lenders would meet. The fact that South Africa has approached the problem not out of step with the rest of the world. By the way, South Africa is very much in tune with the rest of the world, of doing two things. One is taking away that regulatory oligopoly, saying, look, nobody has to use you. You better have a quality product. You better be diligent, reliable, independent, dynamic, or else nobody's going to use you. We've taken it out now of Regulation 28 so that investors can invest in unrated instruments. The ratings are no longer the litmus test or the hurdle. It is an additional thing you might have. Same with the unit trust regulations, that previously unit trusts could only buy instruments that were officially rated by an official ratings agent, and that is no longer true. So ratings agents have to, in a sense, compete now for their business rather than having a regulatorily protected space.
Why is it necessary to regulate credit rating agencies, and in South Africa specifically?
So the second tenet, after we've taken out the regulatory oligopoly, is to address some of the shortcomings that the industry developed. The way the system works is the ratings agents were appointed by borrowers, but in effect they're supposed to act for lenders. People that buy bonds are the lenders. Companies that are accessing capital markets are the borrowers. The ratings agents were appointed by the borrowers, paid by the borrowers, and in a sense beholden to the borrowers. They lost track of their mission in life, which was basically to act for the protection of investors because of who they were paying obeisance to. On top of that, the models that they were using evidently weren't as good as they should have been, or as thorough as they should have been. So the idea, the second tenet then of reform for the ratings agency industry is the Credit Ratings Services Act, which requires, first of all, that they have to be registered, which previously they didn't have to be. They was just they were official ratings agents and they were allowed to do business. Now they actually have to be registered, and they can lose that registration, that right to do business in South Africa. And that requires them to give a whole ramp of information to the regulator, who will vet them about the skill sets, about their boards of directors and the the fit and proper status of their directors and senior management, not dissimilar, by the way, to any other fiduciary business, service business. It requires them to have a code of conduct. It requires them to be more transparent about their ratings methodologies. It requires them to have an independent compliance function inside. So it admits that they are merely a service provider and research service, but because they play a linking and important role in the financial system, that they are going to be held to a higher standard, if you will, of regulatory oversight. So that's the second tenet. You put those together, take away the regulatory monopoly, so they must face competition and nobody's forced to use them, and you couple that with building credibility through a regulatory process, then there may be hope for ratings agents to rebuild some credibility in South Africa.
And what controls do the regulations have over the activities of the agencies?
So the real trick here is to get the ratings agents to stop working for the borrower and get them to start working for the lender. I mean, that's what they're supposed to do. Why do they exist in the first place? They exist because if companies can't access public capital markets or alternative source of capital like pension funds and unit trusts or individual accounts, they can only get money from the banks, which means the banks have an oligopoly, which means the cost of capital for companies will be higher than it would otherwise be. Any time there's less competition, there's going to be higher costs. So ratings agents are supposed to play a linking role. So rather than having, say, 24 institutional investors go and do financial statement analysis, get inside information about businesses, the ratings agents are supposed to do that, produce a good, diligent, thorough report, assign a letter score, which is an opinion of the creditworthiness, and on that basis, investors, if they trust that, can use that research as a tool on which to make investment decisions. And that was the role, that's the purpose. The corruption of the system was that the ratings agents became beholden to the other side of the table. They forgot who they were supposed to work for. They weren't held, and still probably aren't, to a fiduciary standard to look out for investors' interests. By the way, the new regulations also make it clear, and this was always true anyway, that ratings agents could face delictual liability, that is civil liability, if they fail to do the job properly. So if you could prove as an investor that a rating was done and released to the public by a registered ratings agent, and it turned out they didn't do their analysis properly or at all, or they were in some way materially conflicted in doing that work, and it ended up costing you money, i.e. the bond defaulted, they could be sued. That's not new, by the way. I think it was always a part of civil law, but the fact that it's now specifically written into the regulations is quite important.
How will regulating the CRAs promote investor protection? And will these regulations promote transparency and accountability in the CRAs?
Another element is it's easy to look back on the financial crisis and blame the banks and blame regulatory failures and blame the ratings agents and blame everybody else, but the reality is investors were complicit in this. The institutional investors who relied on and still rely on official ratings to do their work for them are not doing the job properly. It is not adequate to say that I will lend money to somebody who's been vetted by a third party. You know, there's nothing wrong with independent research. We use it for a variety of things, whether it's economics or people use it for equity analysis or company analysis or credit analysis. No problem with independent analysis, provided it's independent, but you have to exercise as an investment manager your own judgment. The great failing of the asset management business leading up to 2008, and I say it persists today, is that people rely on other people to form their judgments for them. The ratings agency says it's okay, it's AA, you can buy it, and they do buy it. That is not the way to run an investment process. So insofar as the regulatory change takes away the crutch of ratings agents, that you must use official ratings as your decision tool, it puts the onus back on the asset manager to exercise his judgment. By all means, read those reports, look at those reports. They may add value, they may not make your judgment, but you're accountable. You buy something and it goes wrong, you have nowhere to hide. So I think that improves investor protections pretty radically if it's embraced properly. Now, the problem about embracing it properly is it's a high cost function. It's an expensive thing to run a credit process. It requires teams and analytical methodology, and it's expensive, while bond funds usually pay lower fees than equity funds. When we talk about the Credit Ratings Services Act, it's a good piece of legislation. If you just read the preamble the purpose of the legislation to improve capital markets, to improve transparency, to improve investor protection, to reduce systemic risk. It's got its mind in the right place. It's a nicely drafted, readable, relatively short piece of legislation. It's fairly clear in its purposes and its methods. It's comprehensive enough to cover the industry, and hopefully it imposes a higher standard on the ratings agents. I think there's more that can be done. I think investors themselves should play a hand in choosing the ratings agents that are appointed. Why should we simply accept who the borrower wants to hire? We should say, the investor should say, that ratings agent doesn't understand your business and we want to use this ratings agent. We should be demanding that ratings agents tell us about their staff complements and their skill sets, in the same way that asset managers have to answer for our staff complements and our skill sets, and we can't claim to be all things to all people. We have to say what we can do and what we can do well, and our clients have to assess that. Ratings agents have never stood up to that scrutiny from us, their clients, or from regulators. So hopefully this new evolution of awareness of their role will improve that oversight by the users and the regulators.